automated decision making.
Yes. Right. Thank you very much for inviting me to take an active part in this very interesting event, one of my favorite topics, no doubt. So my name is Cecilia Magnusson Sjöberg. I'm a professor of law and informatics at the Faculty of Law, Stockholm University, associated to Swedish Law and Informatics Research Institute. I'm a subject director and well, I do what professors do, administrate, no, but I do lots of research. Recently I completed a project about e-learning and academic freedom. Right now I'm very much engaged in assignments from the government. I'm chairing or responsible for 2 public inquiries. One is about personal data processing for research purposes in the light of the GDPR, General Data Protection Regulation. And another one is about creating legal conditions for cooperative e-government public sector administration in Sweden. Overall task is to remove unnecessary legal obstacles. You can think what that implies. Anyway, today I'm about to give a talk about automated judicial decisions and privacy or privacy, whatever you prefer. Actually, my doctoral thesis, defended in 1992, was about legal automation, in particular computerization of the public sector of society. I was given the title, and it's perfect, but it's also gives me well, I'm talking, so I'm going to give it an interpretation that is not really focusing on this view. However, I will shed some light on the one hand, legal regulation of the limits of automated decision making right now from the point of view of the European Union. And that's become very apparent listening to the other very interesting presentations today, that what I'm very governed by in my role as a lawyer, lawmaker, assistant, so to speak, and, well, being a citizen within the European Union, because that's really a framework in itself that governs my work, governs my colleagues' work when we approach issues of how to interpret, how to apply legal rules in digital environments, and also how to integrate legal aspects in system design, development, implementation, and management. So what we do within the interdisciplinary field of law and informatics is both traditional ICT law, substantive law issues, and also the methodological aspects of legal system management. So, not least given the title of my talk, but also Karim's presentation, I cannot refrain to say a few words about privacy. Where are you, Karim? There you are. Short. And you said you had a presentation for lawyers and that. So now it's time to talk more about it. Yes. No, but it made me curious, so maybe we can talk about it later. So I'll say just a few words about the notion of privacy in the context of today's legal development, not with any ambition to clarify the legal, philosophical, jurisprudential aspects of it, but just a few words, privacy of today in reality, in practice. And I will say a few words about today's existing governing European Union data protection legislation, because there are things going on. If I say GDPR, how many are familiar with that acronym? GDPR, a few, but not everyone. General Data Protection Regulation. I will then talk about the rule of law in the context of automation, which is actually, I couldn't say more fun, but I find it even more challenging, possibly. Public sector automation, legal information, and the need to transform legal information into algorithms, computer programs. What's in it from a pure legal point of view? And I will say a few words about legal developments and hopefully some concluding remarks. So, about the notion of privacy or privacy, from the point of view, I would say, ongoing legal regulation, and also in the context of privacy as one side of the coin. On the other side, I would say the Swedish are rights of access to public documents, the Swedish principle of publicity. I mean, it's privacy on the one side, and then you have rights of access on the other. And I think we have very much to reflect upon the legal culture, not least, and the historical timing and everything. But you cannot approach, I mean, if you are going to approach privacy as a starting point, you need to make a few very general distinctions. And one is, of course, between physical privacy, flying, security check. I mean, people are touching you, and you have to physically be clarified, so to speak. You have borderline issues, biobank. What is that? In terms of the blood samples and adding to data about the biobanks. But from now this very pragmatic legal point of view, approaching privacy, you need to make a distinction. Are we talking about physical or informational? And I will approach privacy issues briefly from the point of view of informational aspects. And then the way in which these issues are taken care of, so to speak, or rather approached today, brings us very rapidly into issues of personal data processing, all bearing in mind privacy in terms of being let alone, having a right to a private sphere, that you need to differentiate between different categories of personal data, whether it's sensitive, whether it's about personal identification numbers, whether it's in private life or public work life. So, you know, all those distinctions are still very relevant within the broad concept of privacy from a legal point of view, legal pragmatic point of view, not jurisprudential. But very quickly you find yourself in the whole domain of personal data processing, because that's what the legal framework is focusing on to a very large extent. And then you need to further categorize different kinds of data. And then what's quite interesting, and that quite soon you'll also end up in the area of information security. Information security being one way of complying with legal requirements of personal data processing. So if privacy then is the umbrella perspective approach, then it boils down very quickly to personal data processing. And if we are going to accomplish secure personal data processing, you need to comply with very fundamental information security aspects, CIA, confidentiality, integrity, accountability, non-repudiation, traceability, you know, the whole set. And what we see now in recent legislative, not only approaches, but what's already been laid down in law is that we see the lawmaker in a broad sense bringing in information security aspects into the actual legal text. Pseudonymization, making a distinction between anonymization, unidentification, and security terms coming in, adding possibly complexity, but also some clarifications. But there is this these factors, informational privacy, personal data processing, information security, that I would say is a very brief background to what we have now coming. The change of scene in terms of regulation of personal data processing is immense by the fact that by 25th April 2018 we will have a completely new legal framework, the General Data Protection Regulation, which is not the same as what we have today. Today we have European Data Protection Directive, which is implemented into Swedish law, the Personal Data Act. That act will be gone forever by 25th April 2018, when the new data protection regulation will be applicable as law in Sweden and as law in all the other member states. So actually we don't govern privacy in terms of personal data processing within a national jurisdiction. We are definitely merely citizens or part of the European Union, and a regulation decided by the European Union is similar, is equivalent, so to speak, to a law that must be complied with in all member states. And So that's a sign in itself by the European Union moving this data protection reform, moving into a much more strict legal act. And one possibly an alternative could have been that the lawmaker, broadly speaking, will say, well, this is a digital information society. You have to keep it up. I mean, you got to. This is modern. I mean, younger generation. We share all the data. Google, Amazon, everywhere. But I would say it's the opposite from a European Union point of view, in that emphasis is placed on enhanced privacy protection, reduced bureaucracy, enhanced harmonization, reduced, better support for new technical solutions, and also enhancing the digital single market. So that's also quite interesting. It's not only about privacy, it's also about the digital single market. It's for real, no doubt. So if you don't comply with the new data protection regulation, you are at risk having to pay for about 20, well, the maximum is 20 million euros, or 4% of the yearly turnover. So the sanction fees are huge in comparison what we see today. So we, Sweden, as part of the European Union, we are, so to speak, stuck by the legal rules decided. I mean, it's not up to negotiation, it's been decided. So the GDPR is already in force, but it will be applicable by 25th May 2018. Okay, this is law text. This is the regulative approach. This is what we have today in terms within the now until April next year applicable framework. Automated individual decisions, regulated. Well, I'll skip Article 15 because it's more interesting to talk about what's to come. It's even more textual, more words, more complexity. We'll have 99 articles to comply with in the new regulation, and there are about 175 something so-called recitals describing the background of the different articles. Lots of words, logically inconsistent, negotiated, lots of words, lots of obligations. It's good business for lawyers, it's good business for systems developers. It's a whole new branch. All public authorities are obliged to have a so-called DPO, a DPO data protection officer, as a kind of internal controller. So it's a massive change, and that's something one definitely could reflect upon from the point of, is this really meaningful? Is this efficient? Is it really, considering we talked about migration, etc.? Is this really, how to spend the taxpayers' money? But that's a fact, and we are no choice. We are member of the European Union. So what we're going to have next spring is the GDPR, General Data Protection Regulation. We will have a national supplementary regulation, not a new Personal Data Act, but just a general supplementary national legislation. And in addition, I don't know, we have had about 40 different public inquiries investigating into how to adjust public sector personal data processing to the GDPR. Okay, more focused now on the automation. So we already have an article in the now valid data protection directive. What we see is a broadened applicability, a broadened scope in the new Article 22. It includes not only automated individual decision making, but also profiling. And now it begins, right? Because now you get these legal wordings of something that is very technical, and it's a huge, I would say, question mark. I mean, what's there in words? Is that really something that can be translated into legal assessments based on technical, specific application systems? And I'm not going to read it all aloud, but at least the first point is that the data subject is all about the data subject, right? Shall have the right not to be subject to a decision based solely on automated processing, including profiling, which produces legal effects concerning him or her, or similarly significantly affects him or her. So the major rule is really sets boundaries for what is legally permitted in terms of automation. Then there are exceptions, and that's the whole structure of this act. It's major rule, then there's an exception, then there's an exception to this exception, and then there is a weighing of interest. And you are there, and you have to make the decision by yourself. You're the controller at the risk of 20 million euros. So this is just the beginning of Article 22. This is the continuation of Article 22. This is a kind of, it's an art in itself, more or less. And then, in addition, you have a definition of profiling. So here is really an example of when the lawmaker, broadly speaking, tries to regulate technology and automate the processing. Does that imply wholly or partly automated? Is it so, for instance, personal data. What is personal data? Well, that's any information that directly or indirectly can be associated to a living physical person. And indirectly, that's a broad notion. It's very comprehensive. Doesn't matter whether it's you use cryptography or all kinds of anonymization approaches. As long as it's indirectly linkable to a data subject, then it's conceived of as a personal data. Evaluation, etc. Predict aspects concerning that natural persons. I mean, it's right on. I mean, it's what we've been talking about today. And this is applicable by 25th April next year. Okay, so this is an example, not only an example, this is the way it looks from a regulative point of view when it has to do with personal data processing. So I'd like to move on to e-government, or yes?
Is the exception to that one also if they agree to it?
Agree in terms of consent is to some extent under certain circumstances crucial, but it's really important, or an option, a possibility, I would say, but it's really important that you, as a controller, and controller is the organization, it might be public authority or private enterprise, that it is a legitimate consent. And legitimate means that it's got to be a freely given consent after information about the purpose of the data. And here we have one of the major challenges when it comes to big data, data mining, predictive modeling, because one of the major data protection principles in the GDPR, as in the now current data protection directive, is purpose specification and data minimization. So how do you get around that? How do you deal with it? So, and talking about opt-in, opt-out, that's what we're talking about. But then again, it's not legal terms, but it's a way of describing different methods of coping with this legislation. But what I wanted to do is to, we have this data protection regulation, and it's growing. I mean, it's a potential monster, I don't know, but it's huge. And in addition, we have all the e-government activities, digitalization of public sector. It's not as if we have completed it. It's ongoing, and it's my data, and it's, the Minister of Justice says, he doesn't say, but Ardalan Shekarabi, our civil minister, he says that digital first, but then our Minister of Justice says security first, then digitalization, and keep it up. So, we have a huge regulative framework when it comes to personal data processing with its base within the European Union, and we are, as member states, obliged to comply with what's decided in Brussels, right? In addition, we have this constantly, I would say, growing e-government, public sector automation, social insurances, taxes, study administration, environmental protection, etc. It's not as if it's case handling officials actually calculating. It's all automated, right? And so far, I mean, if we talked about privacy, what's the major perspectives when we talk about e-government more specifically? Well, I would say it's more issues about the rule of law. And then again, the rule of law is not legally defined as little as privacy is legally defined or philosophically defined. Within the legal domain, it's quite common that we highlight such words as foreseeability in terms of an individual should have a right to foresee how a case is handling, how a litigation is handled by a court, not necessarily being able to foresee the outcome of a particular case, but the principle. Uniformity, openness, transparency, core aspects. And that we have implemented by ways of principles, to some extent codifications in legislation. And also, it boils down still to people, case handling officials that actually meet the individuals, the general public. But what happens then with the rule of law, legal security, when we automate procedures, when we automate case handling? Well, there is a challenge in terms of predictability, that the foreseeability kind of transforms into predictability, that the outcome, the legal situation is decided when we design the systems, when we code. Code is law, as Lawrence Lessig pointed out. When we decide on how to interpret certain rules, legal rules that include vague concepts, ambiguities, intentionally or unintentionally. And we have to make a distinction between what's specific reasons as opposed to some other reason. What's a reasonable standard level of standard living? And there is a risk that we have streamlining, that the odd cases are not taken care of, and that we have an alienation because the wholly or partly automated means are so complicated that transparency is an illusion. You have to be, or maybe it doesn't even help to be an expert. So, in addition to privacy concerns, I would say there is every reason to also be aware about the rule of law in terms of fundamental concepts of foreseeability, to make a distinction between rule making and rule application in order to keep up with the rule of law as a basis for our democratic society. And why do we have public sector automation? And we've had it since I would say 70s. Well, no surprises, rationalization, mass administration, efficiency enhancement, etc. So it's not really surprising. This is quite interesting when we talk about using automatic means, profiling, supervision. The National Taxation Authority in Sweden often or always almost come out top one when it's about user friendliness and acceptance among the general public. One would possibly expect that public authorities giving us money will be more popular, but they managed to tweak, so to speak, that the National Taxation Authority is very much appreciated among the general public. But it's not as if they show, and it's not as if they publish their algorithms used for selecting taxpayers to be supervised on their homepage. I mean, that's kind of back office routines. And someone said that they tried to get hold of the algorithms, and in principle, an algorithm actually being used by a public authority is an official document, but then possibly public authority may refer to confidentiality rules, but in principle, no doubt that an algorithm incorporated in the computer program is definitely, as a starting point, a public document. Okay, so no surprises why we have public sector automation. It's quite natural if you look about how the society looks on the whole. Now it becomes interesting and tricky. And that's Okay, we know that we have e-government. We know that we have wholly or partly automated decision making. That's actually how our public sector is characterized. And quite standardized solutions, but when public authorities move into AI in the modern form, not like the attempts we made during the 80s with decision support systems and knowledge-based systems and all, but AI and text data mining, etc., calls for some specific consideration when it comes to legal information transformation. Legal information is not, I'm a lawyer, I know, but legal information is not just any other information. Legal information is special because legal sources have different hierarchical status. It's a huge difference between basing your coding of an application on Supreme Court decided cases as opposed to lower court decided cases. And you also you have to deal with such issues as, is it okay to base a certain application, a certain service on not only acts decided by the parliament, but also on ordinances decided by the government, or even worse, if I put it like that, or regulations, provisions decided by the public authority in itself? Very tricky business. Not always. Sometimes the underlying legislation is all clear-cut and is more or less just to code it. But quite often you will find in the seemingly logic, rules and regulations lots of vague criteria that has to be transformed into more strict criteria. And that process, to varying extent, is equivalent to interpretation. And interpretation calls for who has the right, who has the authority to interpret a case, for instance, and say that this case is relevant when deciding in another case, and who has the right to include such a simple thing as a hypertext link to an underlying European Union provisions, for instance. This is really a challenge, and I would personally say that this has to be illuminated to a greater extent. I would say that Arbetsförmedlingen, those National Taxation Office, Social Insurance, those mass administration, huge public authorities have over the years developed much more of legal awareness when it comes to legal system design. But there's still, this is a critical aspect of automation, no doubt. Because then the language of law, and this is really important. What is the legal status of program code, including or dealing with algorithms? Do we need to? Is it just merely, part of administration, or is it more an individual case, or are we actually issuing new rules? And how are we doing that? And furthermore, what are the... it's not as if law is global. We do envisage internationalization of law, but still there are differences, no doubt, between the common law system and the civil law system, and not least the European Union principles. And there are huge differences between legal automation, so to speak, within the public law as opposed to private law. It's much more fun, actually, to develop decision support system for the private law, because you don't have to care about the personal administrative act. You don't have to care about the right of access. Don't quote me, but I'm being recorded, so I was trapped. So there are still quite a few critical aspects. And now, this is news. This is really news. Okay, we're going to have not only a new data protection regulation by 25th April next year, we're going to have a new administrative act by 1st of July next year. It was decided by the Parliament just the other week. And, well, the currently valid administrative procedure laws has actually one subsection obliging public authorities to exchange email messages. That was it. That provision has been removed, but we have one clarification with regard to legal automation, and that is under the heading of the decision by the public authority, how decisions are made. First sentence, provision 28, a decision can be made by a case official alone or by a few together or automated. And that's it. And here we have, we are struggling with these issues now in one of the public inquiries, and what we are thinking about, do we need to legally make a distinction between different kinds of algorithms, those machine learning ones and those that are more static? And why is that relevant from a legal point of view? Well, if you think of a situation when there is a complaint, and if the algorithm is static, then there is not really any point in doing the same routine once again. But what about a machine learning algorithm that kind of adjusts? Then putting in the same case data, there might be different outcomes depending on the machine learned algorithm that has been trained. And then is this something for the lawmaker at all? Is it more for, I don't know. We don't really know to what extent we are still, there is still reason to keep to the approach technical neutral legislation, because that's been governing the approaches by the lawmaker, not least in Sweden, to always strive for public or technical neutral legislation. But the introduction of algorithms, not the introduction, but the use of different kinds of algorithms has highlighted again those issues. If you're interested in the public inquiry that's going to, I'm going to present the result end of March 2018. You have the reference, and this is really, we are struggling. And so in terms of concluding remarks, well, I cannot emphasize enough the need for letting law have a proactive role. We need to bring in the legal aspects, and I think also we need to talk about those standpoints about technical neutral legislation. Maybe time has come for the lawmaker to take a step ahead and actually approach different kinds of algorithms in terms of transparency, for instance. Not that the parliament should design the algorithms or the taxation office as such, but that you have mechanism to keep up with the transparency and the uniformity. And it's getting better in terms of professional rules working together. And yes, please remember that legal information is not legal information. And then I have this final picture, and I realized that it's really, I don't know, I spent some time in Japan, and then, well, robots, they are there and in different situations. It's quite interesting, but then again, it's kind of conventional, so maybe skip the image. But that was about it. So thank you very much for attention.